Hi, everybody. Welcome to this presentation today. I'm privileged to have joining us Erik Rome. Erik is a partner at the law firm of Sage Law in Overland Park, Kansas. You can find his website at sage.law. And Erik is going to discuss with us today some of the ins and outs of revocable trusts, why you might use them, what they're good for, and some of the common questions and pushback that comes along with what you do after you have the revocable trusts in place, such as funding and other issues that tend to pop up like that. So welcome, Erik, and thank you for joining us.
Well, thank you for having me. This is a conversation I have often with clients and probably even more often, with friends and family who are curious about the topic. So I'm happy to talk about it today.
Yeah, we're happy to have you join us. So I guess first and foremost, there's the will that has always kind of been the cornerstone of most estate plans. And, a lot of people, especially clients, tend to know of revocable trusts loosely, but maybe kind of explain the difference between the will and the revocable trust and how the revocable trust kind of fits into the estate plan, especially with a more modern approach to estate planning that we see today.
Sure. So the best way to think about a revocable trust is that it is a will substitute. So everything that somebody thinks a will does, a revocable trust does the same thing, with the one exception that the revocable trust does not have to go through a court process known as probate. So oftentimes if you have a will that says all my property goes to my spouse, and if my spouse isn't living, to my children, and then all of your property would need to go through the court process known as probate, and then eventually get to your kids. What the trust does is it helps you avoid that court process by either titling your assets in the trust or by naming the trust as a beneficiary on your assets. And where I practice in Kansas and Missouri, it's advantageous to avoid the probate process. It's not the end of the world, but it's usually several $1,000s and 6 to 12 months of delay that you get no added value from. More attorney's fees, publication fees, all kinds of expenses. And it's a public forum. So everything's out there as a public record that anyone can look at. I know there are some states where probate may be less onerous, and so the probate avoidance isn't quite as big of a deal. Another thing that often comes up is the ability to manage those assets if you're incapacitated. Where I see that coming into play the most often is if you have somebody with an operating business and they can't afford any delay in the management, the missing payroll, paying vendors, things of that nature. And so if they have that entity titled in the trust, as soon as they're incapacitated, somebody can step right in their shoes and not have to wait to be appointed as a conservator or, over their assets or after their death. And so the loss of time can really, really hurt the value of a business there. And the other component of it is oftentimes you have minor children, you want to create trust for their benefit so that they don't receive everything outright upon reaching age 18. And so no conservatorships have to be set up for them while they're minors. And you can do that through a will or through a trust. And my thought is, if you're going to have the trust set up anyways, you may as well do it through a revocable trust and avoid the whole probate process. So the other common pushback I get is, I don't have enough money to justify a trust. And really, or the question will be, hey, what's the threshold estate size before a trust makes sense? And I don't look at it that way. It's basically, do you want to pay an extra few $1,000s to have your assets probated? Yes or no. It doesn't really matter whether your estate's worth millions or hundreds of thousands. You probably want to avoid that cost. So it's really a will substitute that avoids the whole court process.
Okay, great. You mentioned a will substitute. So if you have a revocable trust, do you still need a will? That's a common client question I see, and I'm sure you run across as well.
Sure, you do still have a will. It's often referred to as a pour-over will. And what that does is, if you have minor children, you are going to nominate somebody to serve as a guardian of the minor children. And if for some reason you don't get all of your assets titled in the trust or payable to the trust upon your death, then it is the only beneficiary listed in the will is the trust. So all those assets pour over to the trust. So it's kind of a safety net if you don't get the asset titling done or something gets missed.
Very true. Okay, and that brings us to our next point, which is the trust, and correct me if I'm wrong, is not a set it and forget it proposition. Just signing it isn't enough. You have to actually go through the funding and titling process. So maybe explain what that looks like, with respect to different assets and the approach you like to take when it comes to actually funding the revocable trust, because that's a common client question and a common advisor question I run across as well. Is how do we get this thing funded after the fact, and how much time is that going to take?
Sure, absolutely. So if you are working with somebody an attorney who does this day in and day out, or a lot of my advisor, partners, they understand the process and they kind of drive it, at least for, the retirement accounts and investment accounts and bank accounts. They're great in staying on top of clients and always checking with them on that. And so I try to work with them to make sure they understand the plan and the instructions, and we work as a team there. But the goal is ultimately to make sure the assets avoid probate. And you can do that by either transferring the assets to the trust during your lifetime or naming the trust as a beneficiary upon your death. And there's reasons you may want to do one or the other. Oftentimes with the residents, for example, I'll do a beneficiary deed or a trust transfer on death deed. And I do that because lenders don't like trusts owning real estate. And so I don't want to have to ask for permission. It avoids probate and we don't have to ask for permission. I think the old way was transfer it to the trust. And then when you want to refinance, transfer it out. After you refinance, transfer it back in. And that just is kind of a waste of time. And so I just generally stick with a beneficiary deed in that situation.
Great.
With life insurance, retirement accounts, bank accounts, investment accounts, you can name a beneficiary, and with the exception of retirement accounts where you usually want to name the spouse as the primary, you can just list the trust as the beneficiary on all of those assets. And with my process, I do what I can in the office. So I'll prepare the deeds, assignments of business interests, assignments of tangible personal property, those types of things. And then I give very specific instructions about what we need to do with the other assets. And I specifically go through the memo. I don't just hand it to the client. And I'm available for calls or emails afterwards. Hey, I got this form. What do I check? And
Mhm.
and through the intake process, if the clients have disclosed all of their assets, it's really a check the box type thing. Okay, I've taken care of that bank account. I've taken care of that life insurance. Once you get it taken care of, you shouldn't have anything left to do unless you buy a new car or a different house or get a new retirement account, and then you need to make sure those follow that same pattern. And I just want to mention a couple other things. Um, I always include in my financial power of attorney documents the authority for the financial agent to change beneficiary designations and to make transfers to a revocable trust, and making
That's a
sure.
good point.
Yeah, because I can't tell you how many times I've gotten a call from, a child of a client, and they said, they're not doing well. Is there anything we can do to make sure the administration process is more, streamlined and simple? And we look and we notice a couple of accounts that are out there, and they're able to, through that authority, get the assets transferred over there. So I don't think the process of asset titling it's basically collecting a few forms and processing those forms with specific instructions. So I don't think it's that big of a deal. Also, one of the pushbacks is, well, if you have a will plan, you don't have to worry about doing any of that. And that's, in my estimation, it's usually not the case. So for example, if somebody has a will that creates trust for their minor children, a testamentary trust, but they, on their life insurance and their retirement accounts, have their kids listed as contingent beneficiaries, that will is not going to control what happens to those assets. And most people name their spouse and then their kids as the contingent. And if they have that set up, that trust, that testamentary trust under the will is kind of worthless. So my point is that you still oftentimes have to look at beneficiary designations and asset titling in a will plan. And so I don't think if you're doing it right, I don't think that the amount of work that goes into a trust plan versus a will plan, as far as fees or amount of work the client has to do, is very different.
Yep, that's a good point. And that's what a lot of people don't realize is those beneficiary designations tend to override the will. And that's a common question I get. And it tends to be a shock point for a lot of clients. So anything else you want to add on revocable trusts and their utility in the estate plan?
No, I have found very few examples of where I have not recommended a revocable trust. There have been times, very specific examples, where I think the clients could have relied on beneficiary designations and a will as a backup. But doing both the planning and the estate and trust administration side of it, and seeing how administration is handled, every day I come to the office, I am more and more of a fan of doing the revocable trust plan to avoid the probate process.
Excellent. Well, Erik, I really appreciate your time in answering the questions today and for your insights on revocable trusts and funding. So if you could please tell us where our audience can find you if they want to learn more.
Right. So Sage Law in Overland Park, Kansas. The website is sage.law. My phone number is 913-341-7800, extension 116. And my email address is erome@sage.law. So happy to answer any questions or help you with your planning.
Sounds good. Yeah, if this sounds good to you, you need to reach out to Erik because he's definitely taken the right approach to this. So thank you so much, everybody, for listening today. And thank you, Erik, for your time and insight. I hope you've enjoyed this presentation, and I look forward to seeing you in our future content.